Hi everyone. Have you ever wondered what happens after a court process? I mean, we all file lawsuits, we all file cases, wherever we are all over the world. Have you ever wondered what happens after a lawsuit if you're not a satisfied party? We've always known on this channel that there's a plaintiff and there's a defendant. However, what happens whether either party is not happy with the decision? In today's video, I'm going to talk about appeals. What is an appellate court? What is an appeal? In general, what is jurisdiction? Everything to do with an appeal. So, let's go. So we ask ourselves, what is an appeal? An appeal is basically the procedure by which a party of a case appeals or may I say, takes up a decision of a lower court to a higher court to convince the higher court that the decision that was made in the court that handled his or her case is either wrong or it needs reviewing. So in other words, an appeal is a process by which a party takes up a decision by a lower judge in a lower case, for example the Magistrates court or the High Court or any court, and takes it up to the higher court, the court which is just above the court that was taking over his or her case, to then do a review, what's called a review. In other words, the judge of the higher court is going to ask themselves, okay, let me ascertain whether this decision that was made by this previous judge was the right one in terms of law, in terms of fact, and the likes. Today we're handling criminal procedure, and appeals are done in many kinds of cases. They are done in family courts, in the high courts, in a number of courts. But I keep talking about court systems. What is a court, or what is jurisdiction? The jurisdiction, or let me just simplify it for you. Jurisdiction basically means your parameters or the boundaries of a court to try a certain case. Many times on this channel I've used the word jurisdiction. You've had jurisdiction in court, you've had it for those who have attended court, you've seen it in the newspapers, you've seen it in magazines, wherever you've heard of jurisdiction. So now that I've told what jurisdiction is, what are the types of jurisdiction? We have what's called pecuniary jurisdiction, we have geographical jurisdiction. Pecuniary means in terms of value of like monetary value. So pecuniary jurisdiction is the amount of money a certain court can try. For example, if it's in between 0 shillings to 5 million shillings or 0 shillings to 20 million shillings. We also have geographical jurisdiction. Geographical jurisdiction basically means if there is a magistrates court in Masaka, then it can only try a case or a crime or any case where the facts took place in Masaka. If we have the High Court of Jinja, then that means that case can now not be taken to the High Court or the Magistrates Court in Kampala. I hope you're following me now. So jurisdiction it basically limits, or it shows the powers of a court to try a certain case, whether it's geographical powers, whether it's monetary powers. But then again, I also keep mentioning court systems. What are the court systems? On this channel I've mentioned them in passing, but let me now talk about them in actual hierarchy. Hierarchy means like from down to upwards. We have the magistrates courts, and even in the magistrates courts we have different grades. We have grade 1. Grade 2 used to be there, but then it was removed and it's no longer, it's basically an obsolete court. So we have the Magistrates Court and the Chief Magistrates Court, which are the most active Magistrates Court. In every kind of sub-county, parish, district, we have Magistrates Courts in almost all the districts, because that is where cases first are handled. So and all of these court systems are stipulated under the Judicature Act of Uganda. Now, the Judicature Act of course stipulates all of these court systems. I've now brought down for you the Magistrates Court. So if we have the Magistrates Grade 1, we have the Chief Magistrates Court. Now after that, we have the High Court. After the High Court, we have what's called the Court of Appeal. Then after the Court of Appeal, we have the Supreme Court. So all of them are stipulated in that kind of order. Like I said, the Judicature Act is the one that talks about jurisdiction of a court. I would like to reiterate again, jurisdiction means the power over powers, or the power of a court to try a certain case. It can either be pecuniary, which means monetary wise, which is money, or it can also be geographical. And there are also other types of jurisdiction, but for today's case, I want you to understand what appeal means. Now that I've talked about what court systems exist in Uganda, what is jurisdiction, I also want to talk about appeal, because appeal comes in afterwards. Like I said earlier, appeal is a process or proceedings under which one of the parties of a certain case is not happy with the decision of his case, his or her case, has taken it up to a higher court for review of the decision of the judge who presided over his case. I've simplified it for you because it's Simply Legal, we simplify the law for you to understand. So now that I've described to you all the court systems and everything leading to where we are right now, I would like to also talk about who can lodge an appeal. Like I said earlier in the earlier definitions and the beginning of this video, the person who can lodge an appeal or who can file for an appeal to a higher court is any of the parties of the previous case. Like I had mentioned, there are different court systems. So basically anyone who has taken, for example, if we have White versus Smith, or in this case we're Ugandans, let's say Kabode versus Musa, then that means if Kabode is not satisfied with the decision of his case versus Musa, then Kabode is one of the parties or is the person who can lodge the appeal. Back to the court systems. In the different court systems, a person who has filed a case in the magistrate's court, either chief magistrate's court or the magistrate grade 1, can then appeal to the high court, because the high court is the court which is just above the magistrate's grade 1 or the chief magistrate's court. I want you to follow me again. Let me just repeat for you to understand. Magistrate grade 2, you will appeal to the chief magistrate's court. So meaning all the lower magistrate's courts which are below the chief magistrate's court will then appeal their cases. For example, if Kabode versus Musa was held in the magistrate's court 2, then if Kabode is not happy with the decision of his case, then he will then appeal to the chief magistrate's court, because that's the higher court. So basically what I'm saying is that an appeal is done only from a lower court to a higher court. It can never be from a higher court to a lower court, because you're reviewing the decision of either the magistrate or the judge in that case. So if my case, for example, if it's Kahuma versus Kabode in the chief magistrate's court, and I, Kahuma, am not, let's say I was the plaintiff and Kabode was the defendant. I, the plaintiff, even if I was the one who brought the case to court and I was not happy with the decision, let's say that the magistrate ruled in favor of Kabode, even if he was the defendant, and I was asked to pay costs, then I will still apply to the high court for an appeal. I will appeal the decision. I'll say, you know what, I still feel like I can win this case because the facts are like this and this and this. I'm going to bring forward the grounds of an appeal, because you don't just appeal just like that, they are grounds. So before I go to the grounds, you must also find out, I would also want you to know what is the time period to bring up an appeal. For criminal cases, given that this is a criminal video, by the way, we don't handle as much criminal on this channel, but I would like to say that I'll be doing a lot of criminal cases or a lot of criminal content still on this channel, because Simply Legal handles everything. Therefore, for a criminal case, you can only appeal a decision by the lower court or by the court that you've been in 14 days after the decision has been made. So therefore, for purposes of people who are in criminal cases, you can only appeal 14 days after the decision. That's in a space of 2 weeks. So, and by an appeal, it's everyone's right to appeal, because in court cases there's going to be either a winner or a loser. It has to be there. There is no tie. For civil cases, it's 30 days after a decision has been made. So therefore, you will have to get the copy of a judgment and everything. I'm going to go to the procedure shortly after this. So now that I have described everything about an appeal, going from the court cases to the time stipulated and who can appeal, let's now go to the procedure under which one can appeal. So what is the procedure under which one can lodge an appeal? Number one, and the very first step, first of all, the person who is lodging the appeal must first of all be dissatisfied with the decision of the lower court or the court which handled his case. Secondly, you must, or the party who is lodging the appeal, must be able to do what's called or lodge a notice of appeal to the appellate court. Like I mentioned earlier, I broke down for you the court systems. So therefore, if Kahuma versus Kabode is in the Chief Magistrates Court, that means Kahuma, who is appealing, will have to lodge a notice of appeal to the High Court, because like I told you, the High Court is the one which is just after or is just above the Chief Magistrates Court. Now, after Kahuma has lodged a notice of appeal to the appellate court, which is the court above the court that has handled his case, which is in this case the High Court, Kahuma will then have to lodge what's called a memorandum of appeal, which will then follow up the notice of appeal. Like I told you, the notice of appeal is the first document you send to the appellate court, or I'm maybe using words which are confusing you. Appellate court means the court to which you're appealing to. Afterwards of lodging the memorandum of appeal, we need to understand that this memorandum contains the grounds under which you're appealing. Don't rush to click out of the video, because whoever clicks out of the video will not be able to know what grounds you can bring for an appeal. Afterwards of you lodging a memorandum of appeal, the notice of appeal will then be served to the respondent. Let me just make it clear. In every case, all over the world, because in Uganda we use common law, but even in civil law, we have what's called a plaintiff and a defendant. When I am appealing, I become the appellant. The person who is appealing becomes the appellant. The person you're appealing against becomes the respondent. So therefore, in this next step, the notice of appeal and the memorandum of appeal are then sent to the respondent. In other words, the person who the appeal is being brought against. Let me just give a vivid example. Kahuma versus Kabode. If Kahuma is the one who sued Kabode in the Chief Magistrates Court, and Kahuma lost, the Chief Magistrate won in favor of Kabode, then I, Kahuma, I will then appeal to the High Court. I will send a notice of appeal to the High Court. I will state that, you know what, I'm sure that I'm going to win this appeal. So therefore, Kahuma, not only he stops being the plaintiff, he now becomes the appellant. Kabode becomes the respondent. So therefore, the memorandum of appeal will then be sent to Kabode, because he's the respondent. Thereafter, the second last step is that a date of hearing the appeal will then come up. The appellant court will now look at the appeal, will look at the previous case, will review the decision of the previous judge, and then set a date for hearing of the appeal. And afterwards, a decision will then be made by the judge of the appellant court, to either be the Chief Magistrates Court if it's from a Chief Magistrate grade 2, or it will be the High Court that is hearing the appeal, or the Court of Appeal, or the Supreme Court. So that is basically the procedure under which you can bring in an appeal, or that you're supposed to follow to do an appeal. Finally, let's go to the grounds under which one can bring an appeal. So in this case, we are looking at the grounds under which you can bring an appeal in criminal cases, because we'll also look at the civil side, but in this case we're doing criminal. One of the biggest grounds under which you can bring an appeal in a criminal matter is in regards to the harshness of a sentence. Now, criminal is extremely wide. I'll do a different video on sentencing, but the harshness of a sentence basically means, like I've handled a few criminal issues here on the channel, we have the Penal Code Act. So if you have issues like murder, manslaughter, definitely a sentence is going to be extremely harsh if it's in a case concerning murder, manslaughter. But what about in the case if the case concerns, let's say, a misdemeanor, or let's say something like money laundering, or something which is a bit slight, something like aggravated robbery, where the sentence is about 6 years or 4 years, then if it has been the state of Uganda versus Kabode, and Kabode committed a crime or a misdemeanor of aggravated robbery or assault, let's look at assault. If Kabode committed assault, then if the judge or the chief magistrate convicts Kabode and Kabode is sentenced to life imprisonment only concerning a case of assault or common assault, then there the lawyer of Kabode can then appeal to the higher court in most cases, which is either chief magistrate's court or the high court. But in most cases, when you look at grounds of appeal in criminal cases, you look at the trial magistrate, meaning he should have been a magistrate of a lower court. So the harshness of a sentence can be looked at. In the case of Ofeda versus Uganda, it was stated that a first-time offender does not deserve a maximum sentence. So even if, in most cases, by the time you're being tried in a magistrate's court, then in most cases you are a first-time offender, if actually all cases or most cases. So the harshness of a sentence is the first ground that I'm giving you. In most cases, you can appeal, or in all cases, you can appeal if you see that the sentence that was given to the accused is so grave in regards to his case. Therefore, let's go to the second one. Now that I've looked at the harshness of a sentence, let us look at whether the trial magistrate erred in law. In law, we call it erred, but for purposes of you understanding, I'll look at erred. So much I'm going to put down the legal profession for a while, or just for this point. When one of the grounds is saying that the trial magistrate erred in law, or erred in law, as my learned fellows would also understand me, it basically means that the trial magistrate did not take into account a number of laws before making his or her decision. Trial magistrates must first take into account a number of things before they make a decision. A magistrate in many cases is a judge. In fact, they are judges, but of lower courts. So by the time you just rush to make a hasty decision, one of the parties will have to appeal because they would feel like you have not taken into account all the laws. For example, in criminal law, we have the Evidence Act, we have the Criminal Procedure Code Act, we have the Magistrates Court Act, we have the Magistrates Act. The Constitution comes into play, for example, articles like Article 28, which talks about a number of laws concerning fair hearing. So when a ground of appeal is taken to the higher court of a decision that was made in a magistrate's court, then in most cases one of the grounds will be saying that the chief magistrate or the trial magistrate erred in law because they did not take into account a number of laws before making their decision. In criminal law, we don't only have statutory law, we also have case law. So in case law we have what's called precedent. So a trial magistrate or magistrate can try a case in relation to a previous case which had similar facts, and that magistrate is relying on the decision that was made in that case. For example, let's say a 1951 case or an East African case but done in another country, or done in Great Britain where our law originates from. So that's another ground. We also have a ground of appeal as to whether the trial magistrate erred or erred in law and in fact. Most cases, this is what's called a second appeal, because by the time someone who is appealing looks at whether the trial magistrate erred or erred in law and in fact, it means that you did not only err in law but also erred in fact. What does this mean? By the time you err in fact, whenever any case is beginning, whether it's in civil or in criminal, we first have to, as lawyers, we look at the brief facts of the case. And of course, judges or magistrates are previous lawyers, or they originated from being lawyers before, now they are magistrates, because we need to understand the law in full. So by the time an appeal is brought on a ground that the trial magistrate erred or erred in fact, it means that they did not understand the facts properly of the case, even when they were making their decision. But many facts of cases are very complicated. We have we have cases of defilement, we have cases of murder, common assault, battery, what you name it. There are millions of cases out there and millions of misdemeanors and felons. So what am I trying to say here? That is one of the ground, that's another ground under which an appeal can be brought. So we have looked at the harshness of a sentence, we have looked at the trial magistrate erring or erring in law, and we've also looked at the trial magistrate having erred or erred in law and in fact. Now, before I wrap up this video, I would also like to bring up the final ground under which you can bring up an appeal in criminal matters, and that's an illegality in regards to the case. So let's say someone committed a crime of defilement. We all know under the Penal Code Act, the sentence for someone going for defilement is either life imprisonment or death. In most cases it's death, because defilement stated under criminal cases is the unlawful and unwanted carnal knowledge with a girl who is underage by a mature adult male man. So an illegality in regards to grounds of bringing up an appeal for a criminal case. So illegality basically in this case, I'll refer to Article 23 Clause 8, which basically states that, in paraphrasing, when a criminal has been convicted under a criminal trial or a criminal court, the time that he or she has spent on remand, I'm sure all of us have heard that Kizza Besigye has been put on remand, so-and-so has been put on remand, David Jamwa and other people. I'm sorry if I'm talking about people who are related to these people, but basically what I'm trying to say is that a criminal who has been put on remand, you could have been on remand for 2 years and then you are finally sentenced to an imprisonment of 15 years. So in this case, illegality means that you did not take into account the time that the criminal spent on remand. So whenever a sentence is being put on these criminals, or whenever a criminal is being sentenced, the trial magistrate or a judge should be able to take into account the time that the criminal spent on remand. So this ground of appeal in regards to illegality means that you can appeal to a higher court, the appellate court, stating that this sentence was illegal because they did not put into the 3, 5, 10 years that this person spent on remand before his decision was then passed or sentenced by a trial judge. So therefore, these are all the grounds that I had for you today. Thank you so much for listening to me. There's something big coming up. I'll never forget to mention that. There is something big coming up that I am planning by the end of the year. It is a solution to all of our legal challenges. It's something that's much needed in society. It's going to remedy all the problems that we have in society in regards to the legal world. So thank you so much for listening to me. For those who are new to the channel, hit the subscribe button. For those who are new to the channel, hit the comment section. My fellow land fellows, my lawyers, my fellow counsel, if there's anything I missed in this video, please let me know in the comment section. If there's something you'd like me to talk about in an upcoming video, please let me know. If there's something you'd like me to talk about in a future video, please let me know. Please hit the subscribe button, like this video because it helps out the YouTube algorithm and promotion of this video. And I'll see you next time. Bye.